you want to have great facts because appellate courts, very much will pick apart bad facts and use it to make bad law, or will not even give you the answer you want on a legal question if there are bad facts. And so that's what the SEC has here. It's better to take an FTX or a Do Kwon case like that up to an appeal, and that would just be a lot safer.
This content is brought to you by VeChain, which is a leading enterprise-grade Layer 1 public blockchain spearheading a digital revolution from a sustainable, highly scalable smart contract platform. The VeChain blockchain has many unique features, which makes it an ideal choice for Web3 applications. VeChain is working with many great enterprises such as PwC, Givenchy, BMW, and Walmart China. Most recently, they partnered with the Boston Consulting Group to build a revolutionary decentralized application ecosystem. I'm a big believer in this project. I have been since 2018. I've been a VET token holder for years. And this blockchain is highly scalable, great with security and speed, and it has low energy consumption. If you'd like to learn more about VeChain, please visit vchain.org. Link will be in the description. Welcome into the Thinking Crypto podcast. I'm your host, Tony Edward, and with me is attorney Fred Rispoli, who's the founder of HODL Law. Fred, great to see you.
It is great to be back, Tony.
Fred, of course, we got the big news yesterday of the SEC Ripple lawsuit ruling and the SEC getting $125 million. And I want to get your take on it. Walk us through the ruling and the outcomes here.
All right. Well, I've had a day to sleep on it and think about it. And there's a lot more nuance in there that, I was picking up on. And I really have to give Judge Torres credit for the way she attacked this, because not only did she do it well on the legal side, but she also did it well to give each side enough of what they want and also fearful enough of what could be lost to really question whether there's going to be an appeal here on this one. And I'll get into that, generally as we go through. But, the bottom line is the order stands for the proposition that Ripple did not do anything with bad intent or ill repute, so to speak. So the penalty was on the lower side. It was a little bit higher than I thought it was going to be, but it was still low in comparison to the $2 billion being sought. And so, that's huge. The second thing, and actually this is probably the most important thing, is that the order that the SEC had wanted the judge to sign, the one they drafted and gave the judge, was rejected by the court. And the court went with a very generic order that essentially says, you are enjoined from violating Section 5 of the securities laws going forward. And, guess what? We haven't been, you and me, we haven't been sued by the SEC yet. But we're also enjoined from violating Section 5 of the federal securities law. So it is, something that is as basic as it can be about, what they're prohibited from in this injunction. And it does leave a lot up for question as to what Ripple can and can't do going forward. But it doesn't explicitly, fight, or it doesn't explicitly destroy their business model, which is what the SEC was going for in this. And in fact, it stayed far away from that. And that was, the best takeaway out of this.
So, Fred, let's say we go back to 2020 when this thing was filed. Obviously, there seemed to be some personal, I don't know, vendettas or shots here because they went after Brad and Chris, right? And they made it seem like Ripple was doing this massive fraud scheme or something like that when it was far from that. So did the SEC kind of shoot itself in its foot by adding all these things to this case versus saying, hey, your institutional sales are problems. Let's talk.
Yeah, the SEC, which it normally does, decided let's go big guns going into this suit, and we're going to throw in the individuals. and we're going to throw our full weight behind this and try and scare them into a settlement on our terms. Ripple survived, decided to fight. Most companies don't, and they survived the initial onslaught. And then after surviving that onslaught, they just got better and better for them as the litigation went on. And people don't forget the Ethereum free pass, but some people maybe forget or don't know that when Bill Hinman left the SEC and said, even before he left and said, I'm going to retire by this date, he continually went back and talked to people at the SEC and really shepherded the decision to sue Ripple, really pushed it through,
Wow.
trying to make sure everybody says, even though we're all leaving, you guys got to still be on board with this and file this suit. And then left and hoping it was all going to go to plan. And I mean, it did take a very long time, but 4 years later, it did not go the way they were hoping.
Mm. So XRP declared intrinsically not a security. Brad and Chris, that case has been dropped. The SEC gets $125 million. Ripple seems to have walked away with the lion's share of the victory here. Would you agree with that?
I would, and I would disagree with the people who are out there saying their business model is significantly damaged or their ODL model is significantly damaged. I just don't see that based on what the ruling was, what the pleadings were going into it. We can get into that, of course, but and also, how the company has responded since the order came out.
So I guess the big question I have is, can Ripple sell XRP to institutional investors, let's say BlackRock or whatever, right? In the United States? I'm assuming no, but can they do it internationally? It seems like they can.
Well, I would argue that they can do it in the US and outside of the US a lot easier, but even inside the US. And the issue with inside and what is specifically prohibited is really depends on what risk that Ripple wants to take. So you have to go back to the summary judgment ruling from a year ago when the judge said institutional sales are what is illegal. And the judge casually lumped in ODL in that category, and there was never really further discussion on that. And then we went into the specifics of what all those institutional sales were. So what they are definitely enjoined from going forward, that there's no question, is exactly what happened as set forth in those pleadings and described, with all the evidence, the contracts, everything. That is what's enjoined. And so Ripple can make an argument saying our sales to other companies of XRP here, even in the US, are so far outside of what we got punished for,
Mhm.
it's just not an investment contract. And the only thing that happens there is that the SEC gets wind of it and they tell Ripple to stop, and Ripple says, no, these are not what we were prevented from doing. And there's a court order that says we are not specifically prevented from this. And I'm talking about the judgment, I guess, and the order itself. So the judgment is the 2 or 3 page document. The order is the 15-page legal reasoning. The judge there is where it gets a little, again, this is what I do appreciate Judge Torres doing, is where she gave enough to both sides. So I'm gonna just look at it so I don't talk too crazy, but
Yeah.
Ripple said, "Hey, get ODL out of this order," and the judge said in her ruling yesterday, well, you know that I had ODL in the institutional sales bucket. You're telling me it's different. Just because you tell me it's different, I'm not buying it. But in the very next sentence, she says, I'm also not buying it.
Mm.
So, she's saying, I'm not going to say that everything you're doing now is totally fine. In fact, you may have still be violating the law, I'm just going to tell you that, you're in for a real whooping if the SEC brings you back here and I find what you're doing is still within the scope of what I told you not to do. So, yes, I would argue they can still sell XRP within the US, even without registration and without an exemption. But it depends on how much Ripple wants to play that to the line, and it depends on how much its clients want to play that to the line. Although the clients don't really need to worry because none of them were taken to court, and they made lots of money, even the ones way back that were at issue in the institutional sales. They made a lot of money on this, so they're very much in the clear. And it really comes down to what we're ultimately going to see is, there are a lot of people saying Ripple only sells XRP and that's its business model and it dumps onto retail. There's other people that say once the switch is flipped, everything's going to go to the moon. And now Ripple is in a position where the emergency cover over the switch has now been unlocked. And so we're going to see, well, was Ripple just for lack of a better word, blowing smoke?
Hmm.
Or do they have a sustainable business model that they can now accelerate into serious growth? And, I believe that they do, and they do have a strong business model, but we're going to see.
Mm, great point. Now there was a question from the community, and I have thoughts around this as well. So let's say institutions are accredited, right? They have all the licenses and all these things. Why can't Ripple specifically sell to BlackRock and that be a securities transactions, but it doesn't affect the rest of the XRP in the open market or the XRP ledger? Can they just get a license for that aspect of the transaction? I don't know if that makes sense.
Yeah, so here's where I know enough securities law to be dangerous because it is incredibly complex when you get into all the rules and specific exemptions, and I'm just not an expert there. But based on my knowledge and understanding, if you're going to get an exemption, you don't even need to register some of those exemptions. You just, have a good faith belief that you fall within there. And again, it would be up to the SEC to figure it out and take Ripple back to court saying you're in contempt of this order. By doing this, this is not an exemption. This is an institutional sale that requires registration.
Hmm.
And so what Ripple can do, if they go that exemption route, there's certain exemptions that they can't do because they've already gotten in trouble by the court. And when you get in trouble and have that type of injunction, it removes some exemptions. And then it also could cause a problem because if you buy the XRP under an exemption, you can't resell it unless there's another exemption. And so that could make it a little more complicated, but it is one route that they could go through is, the accredited investor exemption process.
Mm. Now, big question people want to, or have, I should say, what's going to happen with the appeals? Will Ripple and the SEC both appeal?
So I think that I mean it is as close to a 50-50 as you can get, although I'm gonna lean towards not appealing just because I think there's too many factors that if the SEC is wise and smart, which also is an issue that people might significantly disagree with me on, and I'd probably disagree with me on that too, is that this isn't really the best case to take up. When you're going to do an appeal, you want to have great facts because appellate courts, very much will pick apart bad facts and use it to make bad law, or will not even give you the answer you want on a legal question if there are bad facts. And so that's what the SEC has here. It's better to take an FTX or a Do Kwon case like that up to an appeal, and that would just be a lot safer. So that's factor one against an appeal. I think the penalty, looking back, was probably a great call by the judge because if the penalty was too high, Ripple would surely appeal.
Mm.
If the penalty was too low, the SEC surely would appeal. And, now on this, again, going back to the facts issue, the SEC's got to go back up to the Second Circuit and say that the disgorgement of zero was a problem. Well, the Second Circuit already said that there can be zero disgorgement. You've got a case where there was no investors that said they were harmed. And so the Second Circuit is just going to strengthen that opinion. And that is where the SEC loves filing cases, is in New York, which is under the Second District. So that's a bad idea to appeal there.
Mm.
On the appellate side, Ripple can argue that there is no, essential ingredient to the contracts that they argued at the summary judgment and lost. That's not a very clear-cut winner case right there for them. And the SEC would want to appeal the secondary market issue, which is, that's the one thing that is driving whether they should appeal or not, is we got to get that off the books for the secondary market because, that's critical to how we do this, how we run our enforcement actions, anywhere with crypto. And so, you could get a situation though where they decide, well, let's appeal the Binance one where they said no secondary markets with this exchange
Mm.
and let the XRP one stand. And then XRP and Ripple would be in a unique one-off where those facts have been decided and not appealed. And you could conceivably 3 or 4 years get a ruling that secondary sales are securities generally, and only XRP is now, completely protected from that because that aspect of it wouldn't be able to be changed, or at least a very strong argument that any future decision doesn't affect that aspect of this Ripple ruling. So there's a lot going on. And then there's also the political side of it. I was starting to get worried when I missed my prediction by 7 days that maybe the SEC or that the court was saying, you know what, if I wait until early September to issue a ruling, the SEC doesn't have to make a decision on the appeal until after the election. Judge Torres has never kind of signaled doing anything like that or having those kinds of thoughts go through in her ruling. So it was, but it did start to creep into my mind, but she didn't. And so now the SEC has to make that decision, and Ripple too, by, early October. And
Mm.
so if they do, I mean, to be to be honest, in US politics, a lot of people start making their minds up the month before the election. That's when things get really crazy. That's why there's a term called the October surprise. And so if the SEC has to file a notice of appeal early October, every pro crypto force can say this is another example. Don't believe the reset. Don't believe, anything that this campaign is telling you. They're anti-crypto. And so that's a political headache that they would have to deal with.
Yeah, I was gonna ask you about that because in the context of everything that's been going on over the past 4 to 5 months, I mean, you got Donald Trump, our presidential candidate, calling out the head of the SEC, and saying he would fire him and so forth. You got Democrats turning on Elizabeth Warren and Gary Gensler. And then there seems to be some sort of capitulation with the SEC. They dropped a case against the Binance stablecoin. They dropped a case against Stacks. They dropped the investigation against Ethereum. They approved the Ethereum ETFs. And then there was rumors of the Binance US case. They're pulling out tokens like Solana, Cardano, and so forth. So something is happening here. Maybe that political pressure will influence if they appeal or not.
Yeah, there is for sure political pressure, and eventually some of these things will come out to the public. Some of these things we'll never know. There was extraordinary political. The reason the Ethereum ETF got approved was because of political pressure, and it'll be, I guess, probably not shocking to anybody in the XRP community when they hear how that went down. When that eventually comes out. But there's other things going on that are just phone calls, meetings during, at a lunch, at a popular lunch spot in new downtown, New York. I'm sorry to all my New York fans out there for not using the right boroughs and whatnot, but wherever the courthouse is in New
Manhattan.
York, all the lunch spots around there, and in DC and in the suburbs, and down in all those hangouts where they're having these conversations. And so, it's sad because that's not the rule of law.
Right.
But that has always happened, in America and otherwise, where you have these conversations. And so that's happening, but it's a battle right now between which faction is going to win out in terms of pro crypto or anti crypto. And it's been very encouraging the last, couple weeks and couple months, but you really have to push forward. And, anybody that's very pro crypto, I would just say, and I'm doing this, I'm voting on single issue pro crypto candidates, in my elections. I'm out here in California and nationally, because if I get super rich from crypto, everything I care about, all these other things I care about, social, economic issues, I can do a lot more being super rich than I can be just being, where I am now.
Yeah, and I've brought up that point that first and foremost, people are trying to survive. You have to have shelter, food, and everybody's trying to increase their lifestyle, right? And make it better. And while there are other issues in this election, if you, like you said, are able to grow your wealth and become more financially free, you can then start to address some of those secondary, tertiary issues that you care about. But you can't do that if you're, not able to create that opportunity.
Yeah, exactly. I mean, at the end of the day, what does happen in war, short of getting drafted and sent off to war, or, having federal forces or state forces show up at your doorstep and take you away to jail, there's not much you can do. Now, that's to change things. Now, that doesn't mean give up and, not get involved at all, but just recognize what your limitation is, and recognize kind of what you can do with whatever your circumstances are. And that changes if you have a family, don't have a family, are a business owner or not a business owner. But the bottom line is, the more resources that you have, the more change you can make. And that's just something. And if the way you're going to get more resources is with crypto appreciating vastly, then you just got to solely focus on that side of the wing, on the political election side.
Final question here before I let you go. What are the odds, or have the odds increased, of an XRP ETF being approved by the SEC, given that this thing is wrapping up? And look, I'm not talking this year, but maybe next year. What do you think about that?
I definitely think it goes up because I think there'll be a new regime next year, even regardless of who wins. I think things will shift around. And I think that, even if, you know, on the Republican side, we've got the candidate saying he's going to be extremely pro crypto. The great thing about not being in office is you can say whatever you want. And, we know that Trump's record was not very pro crypto 2016 through 2020. Granted, it's been much worse under the current regime, but those are the facts. And people can change, and I hope that Trump has changed on that topic. But I also think that all the money that is coming into crypto candidates, I mean, there was a very well-known Democratic Congresswoman, Cori Bush, who just lost her primary. There's a lot of factors that went into that, but what people are sleeping on is that Fairshake spent a couple million, or at least over $1 million, trying to get her out because she was anti-crypto. And so that's a message. When you are an incumbent and you lose a primary, that is noticed in the halls of Congress. And so you're going to get a favorable and more favorable than where it is now regime from the Democrats, if they win the election. And so I do think the chances of the XRP ETF have gone up. It'll be a little bit of a kick in the stomach to see a Solana one go first, but I do think XRP is going to be in the top five for ETFs.
Yeah, agreed. And on that Fair Shake Super PAC, it's over $200 million now. I think, if I'm not mistaken, it's the largest super PAC in this election cycle, and it's crypto. I mean, if you told me that in 2023, I wouldn't believe you, but the industry is fighting back, and I don't blame them.
Yeah, it is. I mean, yeah, it's crazy. It's the largest or the second largest. I mean, it is a lot of money. And whether you're a Democrat or Republican candidate, one thing, and whether you agree or not, that moves these elections is money, and you go where the money is. And so, there could be a lot of people. And if they all of a sudden are pro crypto because they're getting money, that's fine because they're expected to keep their promises when they take that money. So, whether they believe in it or not, as long as you get the right laws, right legislation in there, I'm okay with that.
Mm. Fred, I appreciate you, man. I appreciate your insights. Thank you so much for joining me.
Oh, no problem. Let me just plug one thing. I just found out recently on our Songbird airdrop case against Coinbase, we got an oral argument just set in early October, probably right after the day I think the appeals is going to be filed. So I wanted to say thank you to everybody who watched me try and do my best at the oral argument last week or 2 weeks ago against the SEC for the Ethereum case we have. This one's more important for all the Songbird people who never got their Songbird from Coinbase. I'll put it on my X handle. If you watch that, I would really appreciate it.
Yeah, everyone go check that out. I'll put links to Fred's website and so forth and Twitter. But Fred, thank you so much for fighting on behalf of retail investors. And I don't know why Coinbase did this, but I appreciate you fighting on behalf of us.
All right, well, I'll see you later, Tony.